Over $100 million. That's the staggering amount 2 U.S. states, Florida and Georgia, spent battling each other in the highest court in the land, all over a river. This wasn't a philosophical debate. It was a brutal, decade-long legal war with real-world consequences for farmers, fishermen, and millions of citizens. The stakes were incredibly high, with Florida claiming Georgia's excessive water use was devastating its oyster industry and ecosystems, while Georgia argued its economic engine depended on the very same water. The core question was simple: who truly owns the water in a river that flows across state lines? The answer, as the Supreme Court eventually revealed, was anything but. This case fundamentally redefines how states must negotiate shared natural resources, especially as water becomes an increasingly precious commodity across the nation. But the path to that resolution was paved with complex legal maneuvers and unexpected turns. The story begins with the Apalachicola-Chattahoochee-Flint, ACF, River Basin, a vast network of waterways stretching across Alabama, Georgia, and Florida. For decades, these states operated under what's called equitable apportionment, a legal doctrine where the Supreme Court attempts to fairly divide shared resources. But as Atlanta grew exponentially in the late 20th century, Georgia's water demand skyrocketed. Think about it. A city of over 6 million people, plus extensive agricultural irrigation, all drawing from the same river system that feeds Florida's critical Apalachicola Bay. Florida, a state heavily reliant on tourism and its delicate ecosystems, began to see its oyster beds collapse and its unique wetlands suffer. They claimed Georgia was taking too much, jeopardizing their economy and environment. This wasn't just about water. It was about livelihoods, and the escalating tension would soon spill over from scientific reports into the courtroom, demanding an answer to a question no one wanted to ask. By 2013, Florida had had enough. After years of failed negotiations and compacts, they filed a direct lawsuit against Georgia in the U.S. Supreme Court. This is a rare and serious move, as the Supreme Court has original jurisdiction in disputes between states. Florida's argument was direct and compelling. Georgia's unchecked consumption of water from the ACF Basin, particularly for agricultural irrigation in its southwestern region, was causing severe economic and ecological harm to Florida's Apalachicola River and Bay. They presented evidence of collapsing oyster fisheries, a struggling tourism industry, and irreversible damage to the bay's unique ecosystem, which is a vital nursery for marine life in the Gulf of Mexico. Their ultimate request was for the Supreme Court to cap Georgia's water consumption, effectively dictating how much water a sovereign state could use. This wasn't just a request. It was a demand for a judicial solution to a problem that had defied political compromise for decades, setting the stage for an unprecedented legal showdown. Georgia's defense was equally robust, arguing that Florida's problems were not solely, or even primarily, due to Georgia's water use. They pointed to other factors, such as Florida's own management of its waterways, local overharvesting of oysters, and even natural drought conditions. More importantly, Georgia emphasized the massive economic impact a water cap would have on its agricultural sector, a multi-billion-dollar industry employing thousands. They argued that imposing severe restrictions would cripple their economy and unfairly punish its citizens, especially the farmers who rely on irrigation for their crops. Georgia also highlighted its own water conservation efforts, demonstrating that they were not simply taking water without regard for their neighbors. This was a classic legal balancing act: economic prosperity versus environmental protection, all under the incredibly complex umbrella of interstate water law. And the Supreme Court, rather than hearing the case directly, first sent it to a special master. When states sue each other, the Supreme Court often appoints a special master, typically a highly respected lawyer or retired judge, to oversee the case, gather evidence, and make recommendations. Think of it as a referee in a highly complex, high-stakes game. The first special master in this case, Ralph Lancaster, spent years reviewing mountains of scientific data, expert testimonies, and legal argument from both sides. This process alone cost millions of dollars, as each state brought in top legal teams and environmental consultants. Lancaster's role was crucial: distill decades of conflicting evidence into a coherent recommendation for the Supreme Court. The legal lesson here is that interstate disputes are rarely straightforward. They demand an exhaustive examination of facts, often extending far beyond simple legal principles. His eventual recommendation, however, would throw a curveball that neither state fully anticipated, forcing them to rethink their entire strategy and the path forward. In 2017, Special Master Lancaster delivered his recommendation. He sided with Georgia. His reasoning was that while Georgia did consume significant water, Florida had not demonstrated by clear and convincing evidence that Georgia's consumption was the primary cause of Florida's economic and ecological harm. He also argued that Florida had not proven that capping Georgia's water use would actually remedy Florida's alleged injuries, citing Florida's own water management practices and oyster overharvesting as significant contributing factors. This was a major blow to Florida, who had invested heavily in this lawsuit. It highlighted a critical legal standard. Simply proving harm isn't enough. You must also prove causation and that your proposed remedy will actually fix the problem. This initial recommendation sent shockwaves through Florida and served as a stark reminder of how challenging it is to win an interstate water dispute, especially when the burden of proof is so incredibly high. But Florida wasn't ready to give up. Despite the special master's recommendation, Florida appealed directly to the Supreme Court. In a surprising turn, the Supreme Court rejected Lancaster's findings in June 2018. They didn't rule for Florida, but rather sent the case back, stating that the special master had applied too strict a legal standard. The court clarified that Florida did not need to prove Georgia's water use was the sole cause of its injuries, only that it was a substantial factor. This was a critical distinction. The court also criticized Lancaster for not adequately considering whether a cap on Georgia's water use would provide substantial benefits to Florida. This ruling was a massive win for Florida, giving them a second chance to prove their case and forcing Georgia to reevaluate their defense. It revealed the Supreme Court's commitment to ensuring a thorough and equitable process in these complex interstate disputes, even if it meant prolonging the litigation for years. With the Supreme Court's guidance, a new special master, Paul J. Kelly Jr., was appointed. This time, the focus shifted to explicitly assessing the benefits Florida would receive from a potential water cap on Georgia. Both states spent millions more updating their scientific models, gathering new data, and refining their arguments. Florida had to demonstrate not just harm, but a clear, measurable benefit to its economy and environment if Georgia's water usage was curtailed. Georgia, conversely, had to prove that any proposed cap would inflict disproportionate harm on its economy without providing significant relief to Florida. This phase became a deep dive into hydrology, economics, and environmental science, far beyond what typical court cases involve. It exemplifies the extraordinary resources required when states go to court, showing how the legal system tries to balance competing interests using the best available evidence, even if that evidence is incredibly complex and costly to obtain. In April 2021, after years of intense litigation and millions spent, the Supreme Court delivered its final verdict. They sided with Georgia. The unanimous 9-0 decision, authored by Justice Amy Coney Barrett, concluded that Florida had still failed to prove that Georgia's water consumption caused significant harm that could be remedied by judicial intervention. The court acknowledged Florida's injuries, but found that Florida had not met the heavy burden of proof required in an interstate water dispute, particularly in demonstrating that a future cap on Georgia's water use would actually address Florida's problems. They cited evidence of Florida's own poor oyster management, including overharvesting, as a significant factor in the bay's decline. This was a crushing defeat for Florida and a massive relief for Georgia. It underscores a crucial legal principle. Even with compelling emotional arguments, the facts, causality, and proposed remedy must meet an incredibly high evidentiary bar when states demand such extraordinary relief from each other. But what does this mean for future disputes? This case, Florida versus Georgia, sets a significant precedent for future interstate water disputes. It clarifies that simply showing harm isn't enough. The complaining state must also prove, with clear and convincing evidence, that the other state's actions are causing that harm and that a judicial remedy will actually fix the problem. The burden of proof is extremely high, reflecting the Supreme Court's reluctance to interfere in the sovereign affairs of states unless absolutely necessary. This means states facing similar issues in the future will need to build an incredibly robust case, focusing on ironclad scientific evidence of causation and the efficacy of their proposed solution. The legal lesson? Don't expect the Supreme Court to easily step in and reallocate resources between states. They expect states to negotiate and manage their shared resources, and only as a last resort, with overwhelming evidence, will they intervene. This case also highlights the incredible financial costs of failing to reach political compromises. The financial cost of this legal battle was astronomical. Florida spent over $50 million, and Georgia spent nearly $60 million, totaling over $110 million in taxpayer money. This money went to legal fees, expert witnesses, scientific studies, and court costs. Imagine what that $110 million could have done if invested in water conservation, infrastructure improvements, or economic diversification in the affected regions. Here's what happens if states fail to compromise. They hemorrhage resources on litigation, often without a guaranteed outcome. This case serves as a stark warning. While the courts are available for interstate disputes, the financial and political capital expended can be immense, and the outcome is never certain. A common myth is that litigation is always the best way to resolve deep disagreements. This case clearly debunks that, showing the crushing cost and the high bar for success. The real mistake here was the failure to find a political solution before it escalated. So, how can other states avoid such costly legal wars? The key lies in proactive, collaborative negotiation and the establishment of interstate compacts. These are formal agreements between states, approved by Congress, that lay out rules for managing shared resources like rivers. For example, the Colorado River Compact divides water among 7 states, though it faces its own challenges with drought. Step by step, states can 1. Initiate open dialogues early. 2. Commission joint scientific studies to establish common facts. 3. Explore flexible sharing agreements that adapt to changing conditions like droughts. And 4. If needed, seek federal mediation before resorting to litigation. The Florida versus Georgia case is a powerful reminder that while the Supreme Court can provide a final answer, it's often an incredibly expensive and unsatisfactory one. Prevention through cooperation is always the better, cheaper path, saving taxpayers millions and fostering stronger interstate relationships. The Florida versus Georgia case is a powerful illustration of the immense legal and financial complexities when states fight over shared resources. It reminds us that while justice is sought, the burden of proof in such high-stakes cases is incredibly demanding, and the costs can be staggering. The takeaway is clear. Prevention through cooperation is far more beneficial than protracted litigation. If you're wondering what happens when a state tries to seize private land for public use, and how the Fifth Amendment protects against that, check out our next video on eminent domain. It's another fascinating look at government power and individual rights. And for more true legal cases told simply, make sure to subscribe.